The Federal High Court sitting in Yenagoa, Bayelsa State has declared that former President Goodluck Jonathan is constitutionally eligible to contest the 2023 presidential election. Justice Isa Haman Dashin, in his ruling in the suit filed by Andy Solomon and Idibie Abraham, which seeks declaration to the effect that Jonathan is ineligible to contest the 2023 presidential election, ruled that Jonathan is qualified to contest. The plaintiff had sought accelerated hearing, holding that by virtue of the fact that he had taken oath as a president twice and that by the provision of Section 137, subsection 3 of the Nigerian Constitution, he cannot seek re-election. However, Justice Issa, in his ruling, said that the only oath of office taken by Jonathan as elected president was in May 29 of 2011, after he completed the aborted tenure of late President Omare. He also ruled that provisions of Section 137, subsection 3 cannot apply retroactively to deny former President Jonathan the right to contest.
We are talking of the law as it is, not the law as it ought to be. Not the law as it was, but the law as it is. The Constitution says that if you have occupied years, the office by reason of maybe your boss died and you came to complete that tenure, that you cannot occupy that office more than a term again, which he has done, which in this case, if there are facts or common knowledge in that judgment, they are admitted facts. So in the event that those facts are not controverted, which of course are not controverted, we are saying that it's no longer eligible to participate in the 2023 election, and that the second defendant, which is APC, cannot nominate him. And the third defendant, which is INEC, cannot accept the nomination of the first defendant. The court, though, had ruled otherwise. We are eager to have a copy of the judgment as an office. We'll come together, we'll look at it critically. But I can wholly assure everybody that we'll go to the Court of Appeal to test it.
We joined issues with them, and today, in the well-considered judgment that lasted for almost 2 hours, the court agreed with us that, number one, President Jonathan had not contested to the office of the President of the Federal Republic of Nigeria on 2 occasions, that he only completed the term of President Yar'Adua on the basis of constitutional requirement. So he had contested to the office of the President only on 1 occasion. Secondly, the court also held that the fourth alteration, which introduced Section 137, subsection 3, does not apply to disqualify President Jonathan. So in summary, the court agreed with us and held that President Jonathan is qualified to contest the 2023 presidential election.
They are going on an appeal.
Well, when we get to the bridge, we shall cross it. They have a constitutional right.
Well, joining us now is Eric Omare, a lawyer for former President Goodluck Jonathan. Thank you so much for joining us on Newsday. Well, congratulations on this ruling, but I'd like to know, is this a confirmation that indeed Goodluck Jonathan will be running for president in 2023?
Well, I am his counsel. My brief is legal. I think that his spokespersons will be in a better position to answer the political aspect of your question. But what I can confirm to you is that some members of the APC challenged his eligibility to contest. And that case was contested, and today the court ruled that he is constitutionally qualified to contest for the office of the President of the Federal Republic of Nigeria in 2023 because he has been elected to the office only on 1 occasion. And again, that Section 137, subsection 3, which was introduced in 2018 by the fourth alteration, does not apply to disqualify former President Jonathan because a law cannot take retrospective effect. It can only take prospective effect. In other words, it must be events that took place after that law has come into effect. So my interest is more of the legal aspect of it, but that's my brief. The other political aspect, I think his spokespersons will be in a better position to handle that.
All right, Mr. Omare, you've just in your interview we heard a while ago, you said that the plaintiffs are afraid to actually file for an appeal. But do you think an appeal might hurt the chances of former President Goodluck Jonathan to actually vie for a ticket under the auspices of the APC?
Not at all. Not at all. At this moment, there is a judgment, a binding and substituting judgment of court to the effect that is constitutionally qualified to contest. So he has no legal encumbrance at all if he wishes to contest the 2023 presidential elections under any of the political parties. So appeal or no appeal, there is not an encumbrance until a higher court decides otherwise. It's a declaratory judgment, so it cannot even be stayed.
Well, so if this case actually eventually goes to the appeal court, how confident are you, that the appeal court will also affirm this ruling that has been delivered by the High Court?
Well, with all sense of humility, I'm very confident because what the court did, two things. The case of the plaintiff was predicated on two grounds. Number one, that former President Jonathan is not qualified on the basis of Section 137, Section 1B, which has to do with a person that has been elected to the office of the president on two previous occasions. And the court relied on the earlier case of Njoku and Goodluck Jonathan to the effect that Section 137, Section 1B does not apply to him because the oath that he took in 2010 to complete the term of late President Yar'Adua cannot be reckoned with in determining his tenure in office. So that issue has been laid to rest. The second aspect has to do with the new Section 137, Section 3 that was introduced by the fourth alteration. And the court agreed with our contention that has been our position. That look, a law takes effect from the day it comes into being. You cannot make a law to take effect from the past except the lawmakers explicitly say so. And in today's judgment, His Lordship, the judge of the Federal High Court who delivered the judgment, adjustively looked at that provision and held that that law came into effect on the 7th day of June 2018, and it takes effect from that day. So anything, the President Jonathan had acquired a legal right to contest for the office of the president before that date. So you cannot use that law to disqualify him. And furthermore, the court also said that President Jonathan contested the 2015 election with the incumbent President Buhari, and that if Jonathan had won the 2015 election, could anybody have used this law to disqualify him? And the answer is no. So with all sense of humility, we cannot preempt whatever the Court of Appeal will say, but I'm very confident and I'm very satisfied with the judgment of the court today because it reflects the position of the law.
All right, Mr. Omare, let's try to broaden things right now. You asked for an expedited ruling in this particular case. As we delve deeper into the political and electoral season, do you think this should be a norm to help us clear any dead wood and any legal barbed wire, so to speak, that might stop people from getting judgments that might help accelerate or probably disenfranchise them from contesting?
Well, first, we didn't ask for the accelerated hearing. We were not the plaintiffs. I represented President Jonathan, who was the first defendant in the action. The plaintiffs asked for accelerated hearing. The court granted an order ex parte, meaning we weren't there. It was granted on our behalf, and it was served on us. And since it was an order of court, we had to comply with the order. And the order compelled us, mandated us to respond within 5 days, which we did, and came to court to argue our part of the case. Now, with respect to cases acting as a stumbling block, generally, our judicial process, in spite of all the challenges, had always given expeditious hearing to politically related cases because of their time-sensitive nature. But of course, in spite of that, there is no way you can clear all the cases before some elections will be done. But what is important is that generally the courts have adopted an approach that gives priority to handling political cases, and I think that is commendable.
Well, Eric Omare, a lawyer for former President Goodluck Jonathan, thank you so much for joining us on Newsday.